Think twice before adding your child's name to your assets. Many clients come to us believing that an easy way to have their children help them as they get older, or to avoid probate, is to add a child or children to their bank accounts or even to their deeds. Though this might occasionally work in a very specific situation, it usually ends up causing more harm than good. In this video, we will walk you through why we instruct our clients to think twice before adding their child's name to their assets. As we start the estate planning process, we like to tell our client about the 4 Ds: debt, disability, divorce, and death. These are 4 things no one wants in their life, but most of the time are inevitable. Unexpected life events happen all the time, and when you add someone to your bank account or deed, you're also exposing your assets to whatever challenges they may face. When it comes to debt, once someone is a joint owner, they have full access to that asset, and so do their creditors. For example, we had a client whose child was sued after a serious car accident, and because they were joint owners of a bank account, the account was at risk. Another client lost their home because their child, who was on the deed, had to file for bankruptcy after losing their jobs and health insurance due to a medical emergency. Most people don't realize, but medical bills are one of the most common causes of bankruptcy. These situations may seem extreme, but they happen to people every day. Then we think about divorce. Divorce is something you never want your child to go through, but it happens. A former son or daughter-in-law might try to include your account in the divorce proceedings because your child is listed as an owner. Or if your child has named their spouse as their agent under a durable power of attorney, that spouse could gain control over all the accounts your child owns, including your joint account. And finally, death. When there's a surviving owner on a joint account, those assets, whether it's a home or bank account, go to that surviving child. This often leads to angry calls from the other children who are told everything would be divided equally, but the bank says they're not entitled to their share in that account. By then, it's too late to realize that joint accounts pass to the surviving owner, not according to the evenly split distribution mom or dad intended. This very often disrupts the estate plan and creates family tension later on. The bottom line is that there are much more effective estate planning tools that can help us avoid or limit your exposure to these situations. Give our office a call and our team will be happy to assist you.